His Majesty Revenue Customs Part Head.
Yes, Miss Nathan.
Good morning, my lady. You will see that we've been diligent overnight, my learned friend and I, and produced 2 clips of documents. The tabbed ones are from me, and the chitty extract is from my learned friend. I looked at Snell's to start with. I looked at chitty, but I didn't actually think it took as much further, so I thought I'd give you just Snell. But my learned friend has supplied that deficiency. So what I thought I might do is use this as an opportunity, perhaps, to address my Lord Justice Snowden's point about what is the effect of security assignment, first, and then turn to your question to the extent that I've understood it. And we tried
Sorry about that.
No, well, no, it's not so much that. It's what we did in the end was actually look at YouTube to see what was said, and one of my instructing solicitors transcribed the relevant bit. And so I'm going to try and address what I think was the question, but of course you will correct me if I've misunderstood the point.
Well, of course you were faced with me kind of thinking on my seat as opposed to thinking on my feet about, you know, whether or not that was another angle we ought to be considering. So
Absolutely.
I apologise if it wasn't framed with
oh no, well, I mean,
in a way that made it easy to manage.
I'm most grateful for the indication, and in fact, it's obviously more homework has been done overnight,
Yep.
and I propose to address you on that.
Thank you.
It's sequentially, so if I might deal with my
Absolutely.
my Lord's question first. So you will see my Lord.
Just tell us where you want us to put these.
Yes, so I've tabbed them as 39 and 40.
So they're going to supplemental bundle 2.
Yes.
My authorities.
Oh, they ought to actually
up to
go in
26.
Authorities.
You're right.
So they're. I'm going to. Shall I relabel them?
Yes,
27
please.
and 28.
Yes, absolutely. That makes much more sense. And we put them now.
Yes, well, Chitty tucks in nicely behind Benyon.
So I got this right. 27 is the Law Property Act.
Yes.
Is that right?
Yes. So that is the statutory position, and then at 28 is the equitable analysis in Chitty. In Snell. So what I propose to do was just to go through that very briefly now.
Oh, sorry, wait a minute.
So I've got it a bit wrong then. So
Yeah,
I've
yeah.
put Chitty in behind Benyon.
Oh, I see.
Is that what I'll do anything I'm told to do. So
That's very kind. I had actually hoped that the things with the tabs would go in immediately after
Okay.
26.
Yep.
And then Chitty goes in after that.
So Snell is at 27. A bit more Snell at.
No. Law Property Act's 27, I think.
Yeah, but that's also for
Yeah,
Snell,
but
my
it's
lady.
actually-
Oh, right.
Snell.
Okay.
It's
Oh, all
Snell.
in together.
Yeah.
Yes, lovely. Thank you.
And then Chitty at the end.
Thank you.
So would that be 29? I think it's separate.
I seem to have a case as well.
And that case fits in with the equitable analysis. And so I've put it in the same tab, just because it's one of those that's referred to in the equitable part. It's one of the footnotes, so I think I may as well put it in the same bit. So in relation to the legal assignment, I thought it was helpful to start with what the Law of Property actually says. And of course, as my Lord Justice Snowden said yesterday, there needs to be an absolute assignment in writing, not purporting to be by way of charge only. And then over the page, the requirements of the statute are set out in Snell, and it's the part relating to absolute assignment to which I wished to draw your attention. The assignment must be absolute. It is not absolute if it is an assignment merely of a part of a debt, or if the assignment is conditional, or if it purports to be by way of charge only. And then what follows is some more amplification. About halfway down the next paragraph, starting with the word but. Do you have that, my lords and ladies?
Yep.
So, but an instrument which appears to be intended merely to assign only so much of a debt as will provide security for the repayment of a specified sum is not an absolute assignment. Being made by way of charge only, also an assignment is conditional and not absolute if it provides that the assignment is until the money with added interest be repaid to you, or if it provides for the assignor to be entitled to exercise all rights over the property until default by the assignee under the loan agreement. In each case, it is necessary to consider the language of the instrument as a whole in order to determine whether or not the assignment is absolute. And then I've included point 3, part 3, the completeness. I didn't intend to draw it to your attention. And then 4, the document with the title 4, effective assignment. An assignment which complies with the statute as to the notice and otherwise is effectual in law, subject to equities having priority over the right of the assignee to pass and transfer from the date of such transfer the legal right to such debt or thing in action, all legal and other remedies for the same, and the power to give a good discharge for the same without the concurrence of the assignor. Thus the assignee becomes the owner of the shows at law and can sue the debtor in his own name without joining the original creditor, who has no further right to the shows. The effect of assignment on equity is considered below. So that's the effect of an absolute assignment. But we say, of course, we're not in that world. I've included Westerton because Westerton is mentioned at footnote 54 of the document we've just looked at for effective assignment. And so I've just included Westerton should you wish to go to it. And then moving on to the equitable position. This, again, the document starts 1, relation to a legal assignment. You have that, my
Thank you.
ladies, thank you. An assignment which does not comply with the statutory requirements is not necessarily ineffectual, for it may operate as an equitable assignment. The statute does not forbid or destroy equitable assignments or impair their efficacy in the slightest degree. An assignment which fails to satisfy the statute because it is not absolute but conditional, or by way of charge, or because it is only an assignment of part of the debt, is nevertheless fully effective in equity. So also an absolute assignment may at first be merely equitable, and then, when the necessary notice is given, becomes statutory. So what it distinguishes between what is and what isn't an absolute assignment at law, and then essentials of equitable assignment. I've included it to show the sorts of things that are required. I didn't intend to take you to it.
I don't think that's necessary.
Thank you. Then the following document is headed 3, effective equitable assignment. Within that same clip.
Yes, thank you.
Yeah. So it distinguishes between the situation where the whole interest is assigned and some interest is outstanding. Might I just invite you to read that to yourselves?
Thank you.
And what I've done in the hope of being helpful is include the case that is referred to at footnote 118 of that article that you've just read, the Deposit Protection Board, which I hope is the correct reference. But the reason I included it is because there's quite a helpful summary in the Court of Appeal judgment of I think it's Lord Justice Simon Brown, and that's to be found at the bottom of page 11 of the printout.
Is that the part that at some stage has been highlighted?
Yes, I thought I'd take the liberty of doing that.
No, that's
draw
helpful.
your attention to it.
That's very helpful. Would you like us to read that?
Would you please? I'd be most grateful. The point I thought came closest to helping us answer, broke towards an answer anyway, was point 3. But again, it begs the question, what is comprised within the concept of legal owner? Clearly, it covers somebody who has a legal title, but given that, that there is not an absolute assignment, there are some retained rights, there must be a position, we say, in equity as well as an owner for the assignor, because it isn't an absolute disposition or a disposal that exhausts all his rights in the property. A way of cross-checking that would be to say that the assignee of a non-absolute assignment, such as by way of charge, is not able to deal with that asset by himself unilaterally. He must join the assignor. And so we say that that although not explicitly so stated within point 3, legal owner will subsumes some quality of equitable ownership as well. So our position here is that the terms of the security assignment ensured the assignment only took effect while the loan interest obligation was outstanding. So the security assignment was not an absolute assignment and took effect as an equitable assignment only. Mr. Good, as the assignor, remained the legal owner with, we say, some equitable interest, some equitable ownership interest in the property, i.e. the maps at the time that they arose. When the maps arose, they were impressed, we say, with the conditions as to their use, which were imposed by Clause 3.1 of the security assignment. The continuing effect of the conditions as to the use of the maps when they arose meant that Mr. Good had a continuing, non-exhausted interest in the maps, and that they would be paid to him once the loan obligation was extinguished, and that we see that with the release and reassignment point clause within the document. If you'll note, it's at clause 7 of that document.
But you wouldn't have needed clause 7, actually, would you, given the terms of clause 3.1, which said the security assignment was only for the duration of the loan.
Absolutely.
So it's belt and braces, isn't it?
It's belt and braces. The interest was sufficient, we say, the interest retained by Mr. Good was sufficient, we say, to amount to an entitlement for the purposes of 611. This then brings me to the other question, and this was the one posed by my lady at the end of the hearing, which, forgive me for this, but when one transcribes something, it always comes across slightly oddly. But I think, the thing
mortification of live streaming.
So I asked for pardon before I even say it, but I think the point that arose from the passage was the fact remained Mr. Good was, as the legal owner of the maps, entitled and continued to be entitled to payment to him under the contract, but subsequently assigned them to the third party, the bank. In other words, is there an analysis that says an entitlement from two directions, one from a continuing entitlement as the legal owner of payment under the contract, and secondly, however you define the continuing residual entitlement to the assignment? Or am I wrong as to that? That was your question.
Oh, it's not as bad as I thought.
It's always nervous
Yes.
when one sort of
I
reads
can
something
uncurl my
that's
toes.
But our answer is this, that shortly, yes, I think there is another way of interpreting this. And if I may amplify that, Mr. Good is entitled to the maps as consideration for the disposal of the distribution rights, of the film rights under the distribution agreement. And it is part of the consideration for that disposition that he's entitled to the maps. That's under clause 3.1. And he remains that person throughout. That is not disturbed by anything that happens. And we say that because the payer, that is distribution, is not a party to the security assignment. And I'm grateful to my lady for pulling out that point, because it does put everything into much sharper contrast. So that's the first point. He's not a party to the security assignment. The payer, that is the distribution, is obliged to pay the maps under the distribution agreement to Mr. Good. That's how that document works. So without more, Mr. Good has both the entitlement to the payment and the right to receive the payment. And therefore, he could satisfy both parts of 611, person receiving as well as the person entitled to the payment. So what is the position? What happens as a result of the security assignment? Now, one view of the security assignment, and I'll go through the linguistic analysis in a moment. One view of the security assignment is that it does not affect entitlement, but only the person who receives the payment. So the person entitled to receive the payment becomes scion lender, but again, that is closely circumscribed. It's by way of charge and for the discharge of the loan. So if one were to read this paragraph, clause 3.1, if I could invite you just to turn that up, please. Clause 3.1 of tab 38, security assignment. So what I'm proposing to do is to read this passage, omitting those parts that aren't directly relevant, and then to draw out certain points in relation to those. So you hereby unconditionally and irrevocably assign with limited title guarantee. My lady, you'd asked yesterday, what does limited title guarantee mean? Well, I looked it up, and although I don't have authority for that, it wasn't a very deep research, I'm afraid. But what it basically means is that you cannot guarantee what has happened to the property, except to the extent that you haven't added encumbrances to it.
Oh, thank you. That's very helpful.
I think that there are 4 implicit things that happen when you give an absolute title to property. And the fourth of those is the thing that isn't guaranteed when you come to give limited title to guarantee. Limited title guarantee, i.e. that you cannot say that it's free from all encumbrances. All you can say is that you haven't done anything. But anyway, so assign with limited title guarantee for the payment and discharge of the secured obligations to the lender by way of security, and then skipping forward, the benefit of your present and future rights under the acquisition agreement, including the distribution rights acquired thereunder and the distribution agreement. Now, this is I think, the problematic passage. So, first question, what does distribution rights here mean? So, there is no specific definition of distribution rights in the additional terms of the acquisition agreement. It defines distribute and assigned rights. And if I could just ask you to go to tab 23 of the bundle you've actually got in front of you, keeping a finger, if possible, in clause 3.1 of the assignment. So tab 23 to page 415. That is Schedule 1 of the additional terms to this document. The additional terms themselves start on, excuse me, they start on page 397. So if one starts at page 397 of the bundle, you've got definitions. The first definition is assigned rights. Shall mean the distribution rights specified in Schedule 1 hereof for the film and territories identified in paragraph 1.2 of the basic term. So that would be, in our case, tenure.
Sorry, I think I'm in the wrong place.
It's page 397.
Oh, sorry, I was on 415.
Yes, 415 is Schedule 1, to which I was about to take you, but why we go there is told us by what's on page 397.
I'm running out of fingers. Right, 397 on there.
Yes, so definitions under additional terms, 1.1 assigned rights, and that tells us assigned rights shall mean the distribution rights specified in Schedule 1 hereof for the film and territories identified in paragraph 1.2 of the basic terms. And then when one scrolls down to look for any definition of distribution rights, because they appear also in assigned rights, but without capitalization, we don't find a definition of distribution rights. We do find distribute, shall mean distribute, exhibit, advertise, promote, or otherwise exploit the film. And distribution agreement, obviously, is the distribution agreement. So we're not told any more about what distribution rights mean by any specific definition. If we then go to the definition, or follow the definition of assigned rights to Schedule 1, which is at page 415, you will see that Schedule 1 has a sort of preamble bit, and then it's got sub 1, which has definitions in bold of general distribution rights and non-theatrical distribution rights and theatrical distribution rights. So the distribution rights are, as it were, defined in the context of assigned rights, but nothing greater than that is told us about what that means. So assuming that distribution rights means no more than the rights that are acquired by Mr. Good in respect to the film from the rights company, which itself has acquired it from the external producer film entity, those rights are then capable of being distributed by him, and that those are his distribution rights in relation to the thing that is acquired. It is that which is then the subject of the disposition under the distribution agreement, and which gives rise to the entitlement to maps. So going back here, so you unconditionally hereby assign, irrevocably assign, so we're back at 3.1 of the security assignment, the benefit of your present and future rights under the acquisition agreement, including the distribution rights acquired thereunder and the distribution agreement. Now, the infelicity with that formulation is it's not clear what is qualified by the term including. It precedes both precedes the distribution rights, acquired thereunder, so that would be a clear reference to the acquisition agreement, and the distribution agreement. So does it include the distribution agreement, distribution rights acquired under both the acquisition agreement and the distribution agreement, or just under the acquisition agreement? I think, standing back, I don't recall there being any rights acquired under the distribution agreement for any distribution rights acquired by Mr. Good under the distribution agreement. Quite the contrary, he disposes of them. Yes. So perhaps the better way to read that passage is to treat the and that follows thereunder as disjunctive, so that the benefit of your present and future rights under the acquisition agreement, including the distribution rights acquired thereunder, and then to have a separate, as it were, subparagraph, and to link that to the you hereby unconditionally and irrevocably assign with limited title guarantee by way of discharge the benefit of your present and future rights under the distribution agreement, including without limitation the benefit of all your income or monies payable to you thereof, and then it goes on about the various sums and proceeds and the like. Now, there are two ways of reading that second bit, treating it as all the rights under the distribution agreement. Does it mean that it covers the entitlement to the to the maps themselves, or does it mean that it's who receives the money? And we would say that it looks at the money and the receipt of the money rather than the entitlement under 3.1 per se.
Can I just be clear about that submission, just to make sure I've understood it? So is that looking at the words, including without limitation, the benefit of?
Yes.
Are those the words that you attach this analysis to?
Yes,
so
the benefit of all your income. So it's basically everything that follows. Yeah, that everything that follows from the word from after distribution agreement brackets everything that follows that. So and what we say is it could be said to cover both rights. The right to receive, the right to the maps and the right to receive the maps, or it could be simply to look at the amounts that are to be received and to say that they are to be received by somebody else. And we say that the focus on the proceeds, the sums, the repayment of purchase price and the like, focuses on amounts received, to be received, and who is supposed to receive them, rather than cutting it into the entitlement under clause 3.1.
It would sit more comfortably with the fact that it's an equitable charge.
Absolutely, my lady. Exactly, and I think it's a consistent reading with the understanding of what this assignment seeks to do.
And going back to our earlier point, it would be more consistent also with the fact that there's only two parties to this agreement.
Yes.
The person who's obligated to pay is not a party to this.
Exactly, my lady. So I think of the rival interpretations, the better view is that all this does is affect the destination of the money into the hands of a different recipient, rather than cut across the Mr. Good's right to the consideration for the distribution.
I mean, that's not the conventional analysis of a charge. I mean, the charge is normally, in this case, on the receivable, i.e. on the shares in action. And the consequence of it being an equitable assignment is that the conventional, the modern analysis that I certainly understand is that an equitable assignment leaves ownership in the hands of the assignor of the shares in action, but that money may be directed to be paid to the assignee for so long as the security is outstanding.
And my lord, I don't think that I'm disagreeing with that.
Okay.
It's just the destination of where the monies go that is determined, we say, by clause 3.1.
I mean, the one way of testing this, and in fact this is the way that a lot of the cases actually arise, because a lot of the cases, including the one you've referred us to and a number of others, are all to do with who's entitled to sue.
Yes.
The question is, and so to put it in our case, the question is, would Scion Bank be entitled alone to sue distribution, whatever it's called, SDL? Is it SDL it's called? SDL?
Yes, distribution, yes.
So would the bank be entitled to sue distribution without joining Mr. Good?
And our answer is no, because it's not an absolute assignment, and that's clear from the cases.
And if Mr. Good has to be joined to the claim, then that's because he has an interest in both the shows and the destination of the proceeds. In other words, he hasn't fully discharged his interest. He hasn't fully disposed of his interest. That's the way that a lot of these cases arise. And
yes.
I think, but I obviously people want to be educated by Mr. Baldry as well. But that seems to be a way of testing how matters could go. And it is interesting that when you look at, I don't know whether this is, were you going to take us to the notice?
I was happy to go to the notice after this, but
Okay.
I'm happy to go now too.
I mean, one of the points that could be made, I think, on the notice is that the notice doesn't actually contain a promise by SDL to pay the bank. I mean, all it actually does is it's a notice by sole trader and Scion Bank. I'm not quite sure what Scion Bank's doing, but anyway, sole trader notifying SDL to pay. There's no actual promise by SDL to do anything other than, to do anything. In other words, it's simply a direction. So if you were to ask the question, could Scion Bank sue contractually without joining sole trader? At least provisionally, the answer appears at the moment to be no.
Yes.
Now, I'll obviously want to hear Mr. Baldry on that question, but you presumably would say quite so.
Quite so.
Right.
Quite so, man.
Yeah.
That's what you would say. This is no more than a notice and an acceptance that once Scion Bank receives whatever it receives, it will use it to discharge the debt. But that's what it's required to do in any event under 3.1.
I mean, you give notice to. You have to give notice if you're trying to do a statutory assignment under Section 136, and that is what, as it were, if you comply with the statute, that means that's why the assignee can sue the debtor direct without having to join the assignor. That's what a statutory assignment achieves.
Yes.
If it can't be a statutory assignment because it's by way of charge only, you can still give notice to direct the debtor to pay to the assignee, because that, in a sense, provides you with, if you're the assignee, with extra protection.
Yes.
But if the if the debtor was nevertheless to ignore the notice and pay the assignor, your right of action, I think, would be against the assignor, saying you've actually received the money contrary to the agreement of charge which we have entered into, handed over.
Yes, I mean,
if you, as an assignee, if you want to protect your rights as against the debtor, In other words, if you want to try and enforce your rights as charge holder against the debtor, you have to join the Assignor.
Yes.
Because it's not a statutory assignment. That's my very basic understanding of the triangular.
My lord, you have the
Set of
advantage of me on your very basic understanding. It's to the extent that I can add anything to that, I would say that everything you have said is consistent with what with the extracts that we've produced from Snell's.
Yeah.
And it's also consistent with paragraphs 6 through to 8 of the principles summarised in the Deposit Protection Bank.
Yeah, I mean, there are cases which deal more specifically with the nature of a charge, and there's lots of legal writing in various books dealing with, you know, this analysis of exactly where does contract begin and end and property come into it, and how does an assignment fit between contract on the one hand and property on the other.
Absolutely.
There's reams of stuff about it, but you in any event say, standing back, the Assignor has not dropped out of the picture.
Absolutely, that's what we say. It's not an absolute assignment, it is by way of charge. The Assignor retains legal ownership and, we say, is somebody who hasn't divested himself of the totality of equitable ownership, because he has, quite apart from the fact it's by way of charge, the terms of that charge require it to be used a certain way, and those terms subsist and take effect at every point that the sums that are the subject of the charge arise. So we say that there is legal ownership, there is equitable ownership, both in the hands of the Assignor, and therefore he is somebody who remains entitled, for the purposes of 611, to the maps when they arise. I don't think I need to labour that point any further now. Might I move on to a couple of the other points in relation to grounds 1 and 2, which I'm sort of treating together. My learned friend said that that it was wrong of the upper tribunal to consider that that more than one person could be chargeable within the scope of 611. Both on obviously that is wrong on one basis, which is that there are two alternative bases for charge: a person in receipt and a person entitled. So the legislation itself contemplates two alternative people who could be within the scope of the charge. But it's also possible, we say, for there to be two persons who are both entitled. I mean, for instance, you might have a joint bank account and the interest arising is jointly so held. So both persons are entitled. The point that there might be a choice as to who to go against, we say, isn't enough to override the clear words of that that legislation. My learned friend I was going to make a couple of points, but actually in relation to the security assignment, but I think those points have been made. The important point to note, though, is that the analysis that we're putting forward here, i.e. that this is that Mr. Good remained a person entitled to the maps, is entirely played out with the way in which he completed his returns, the scheme devised the scheme, the documentation that went with the scheme, the business plan, etc. And Sion issued a summary profit and loss account figures for each year, which were then used by each of the scheme users. And these sums included the maps as part of the turnover and the interest that was paid. And we have, should you need finding a fact to that effect, it's set out in our skeleton argument, but it's also the FTT decision paragraphs 9, 1 and 2, which are in the core bundle 10, tab 10. And to the extent that my learned friend yesterday tried to say that they were incorrect, that the accounts produced by Sion, the summary profit and loss accounts produced by Sion, were incorrect and did not reflect the true position, is in our respectful submission untenable. The bottom line is that the participants in these arrangements wanted to carry on a trade. They needed to show that there was income. This was the income that they were guaranteed to receive, and therefore it was income that needed to be reflected in their turnover stroke in the turnover part of their profit and loss account. And therefore, it is, although what they did was not enough to amount to a trade, it doesn't mean, as my Lord Justice Snowden pointed out to my learned friend, that those things didn't happen, that there were acquisitions of rights, there were disposals of rights, the disposal of rights gave rise to the maps were received and were included within the account. So it's no answer to try and resile from that just because it's not a trade that is being argued for, but a charge under the non-trade exploitation of films head of charge that is now in play. There's a small point, and it's just a point of detail. It arises from a point that you made yesterday, my lady, about the quantum of the charge on maps that is currently in play. There are 3 years of account that are within the scope of this appeal. That's 10, 11, 11, 12, 12, 13. Maps were due to be paid from year 2, not in year 1. There was no maps for year 1. Year 2 through to, I think it was year 7. The last 2 years, that's 13, 14, 14, 15, nothing was paid in terms of maps. So, but there were maps paid for years 8, 9, 9, 10. Those aren't within the scope of this appeal, but I believe that those matters remain open. I've just got confirmation. So that the total
Sorry,
amount...
which years again? Sorry, which years are still open?
that would be years 2 and 3, so that would be 8, 9, 9, 10.
Thank you very much.
So the only years with which you are concerned here were the discovery assessment years, and those are the 3 years that are before you. The fact that the...
was nothing paid in the last 2 years because the whole thing had sort of collapsed and was... I suppose it's
I
not
would be
for you to answer.
speculating. I'm afraid I would be speculating.
But I think I did read, didn't I, that they weren't being pressed for the interest.
Yes. I mean, nobody had to put their hand in their pocket, I gather. That was, I think, that was one of the findings in the FTT decision.
It was.
The other, so they included the maps within their tax returns. P&Ls have included it, their tax returns included it, and as it were, the icing on the cake was they also included a claim for interest deductions in order to reduce the bill to 0 or create a small loss in that year. So the fact is that they believed that there was a reality to the maps. They believed that the maps were their income. Now, to what extent is that a legal analysis? Well, we say it's a cross-check. It's whatever is now being argued. It's inconsistent with the way in which the taxpayers themselves behaved at the time when they were looking for a particular outcome. And that was the treatment that they chose even after the security assignment. So the argument that is being run today is not one that was in the minds of the people devising the scheme or the taxpayers at the point at which they were making their returns. So I don't want to labour the point other than to say that you have my submissions on the effect of the security assignments, that it doesn't on 2 bases affect the entitlement under Schedule, under Clause 3 of the distribution agreement. One, he remained the legal owner and the person to whom the monies were due at all times, and that didn't change just because the security assignment was signed. But even were that not to be the correct analysis, the fact is that he maintained his entitlement because of continuing rights over the maps. And we say that the upper tribunal did not err in its analysis when looking at the effect of the documents. This may bleed a little bit into the next question, which is composite transactions versus looking at the specific part of the arrangements. But the tribunal was alive to the relevant principles in relation to composite transactions and how to view them. It cited the UBS principle in 68, which is that some provisions require you to, some provisions engage a wider review, such as trade, if you need trade losses or if you need whereas some require you to focus very definitely on a specific aspect. So, for instance, the lessor's entitlement in BMBF required one only to have regard to what the lessor had done. Did he pay money? Did he acquire the rights in the pipeline? Ditto, Westmoreland had the interest been paid? Yes, it had, even though the funds for the payment had come through a circular route. And we say this is a similar sort of case. The legislation looks at who is the person receiving or entitled to the maps. And that requires one to look at what are the things giving rise to the maps, anything cutting across the things giving rise to the rights giving rise to the maps, and to determine whether Mr. Good remained the person entitled. And therefore, the upper tribunal is entirely right to look not just at the security assignment, but to look at the loan agreement, to look at the security assignment, and look at the distribution agreement, and note that the distribution agreement, the rights under that, were not cut away by anything that happened in the security assignment. So we say that the tribunal the upper tribunal correctly understood the principles to apply and applied them correctly to the facts of this case. My learned friend, in his skeleton argument, but not orally, raised the relevance of genius. We maintain the arguments we put in our skeleton argument. I don't need to repeat those, I think. So that brings me on to the ground 4. The alleged error is that the UT erred in holding that the maps were income from a business involving the exploitation of films. Now, to the extent that it said that it's because these were not performance-related amounts, but were guaranteed amounts, that somehow that meant that they weren't, in fact, receipts from the exploitation of films. We say that that is wrong. There is no limitation in 609 that requires the receipts to be, the sums arising, the income arising to be performance-related. It is any sum arising from the exploitation of films. And clause 3.1 makes it clear that there is a direct link between the disposal of the film rights to distribution and the consideration paid by distribution and payable by distribution to Mr. Good. And that arises from the disposal of film rights. Therefore, it falls clearly within section 601. It's not within the bundle of authorities, but to the extent that it is said that the basis of computation of the amounts, i.e. that, not that they're not performance related, but that they are computed as a part, as a figure related to the amount outstanding of the loan, that somehow changes the character of the amount. We say that that isn't right, because the character of the amount is determined by what the amount is, and the amount here is consideration for the disposal of the film rights to distribution by Mr. Good. The case to which we referred, the upper tribunal below, but isn't in the bundle here, just for your note, is London and Thames Haven Oil Wharves and Atoll, and it's 1967, CH 772. It was before the upper tribunal below, and we surmise was the reason they said that the basis of computation doesn't determine the character. May I just check with those behind me?
Certainly.
My ladies, my lord, I have no further submissions to make.
Of course.
Just wanted to check a couple of things, please, Miss Nathan. Mr. Baldry invited us in the context of construing section 609 to 611 and so on to take account of the settlement code. I just wanted your answer on that, because I think what he was saying, you'll forgive me if I misphrase it, I'm sure he put it more elegantly than I will, but that there's a specific set of provisions that deal with retained benefits and where you have benefit splits and so on, so that's really the answer, and that we shouldn't read something similar into section 611. Can I just have your answer on that?
Well, my lady, the answer is that settlements codes apply where they apply.
Yeah.
The fact that they exist, similarly the transfer of assets provisions, where they apply where they apply. But the fact that they exist on the books does not mean that the clear words of the statute should not be taken to mean what they mean. The statute raises two alternative bases of making a person liable.
The second one was really just standing back a little bit, and it's just a slight nag that I've had about this case, and I just wanted really your answer to it. But there is, because this is a film scheme that didn't work, Mr. Good has lost his investment in the film scheme and it's all collapsed down. There's a slightly penal quality to now going after him for tax on part of the mirage, you might say, that was erected in the first place. And I suppose that's a point of construction. You know, can we be sure that section 611 and the reference to payment and entitlement or receipt and entitlement was meant to apply in these sorts of circumstances?
I take the point, my lady, and my answer to that would be this, that nobody has argued sham here. Everything here took effect. There were real acquisitions of rights, there were real disposals of rights, there were real loans, and those loans needed to be paid. Loan interest needed to be paid. Nobody has said that those things didn't happen. So they weren't enough to amount to, they and whatever Mr. Good did, weren't enough to amount on the state of the case law to a trade. But there is a clear finding that there was a non-trade exploitation of films business, because there was the acquisition of rights, the disposal of rights, the application of the mind of Mr. Good to whether or not to acquire the rights. Now, as part of that package to, as it were, create this business, a non-trade business, he became entitled to part of the consideration for the disposal of his rights. And the question really is there income to which he's entitled or received? And we say, yes, there is, because the maps were meant to be paid as consideration, were paid as consideration in the years with which we're concerned. And when one asks, standing back, looking at the statute and looking at the concept that the statute is looking at, it is looking at, is there income arising here? And there clearly is income arising here from the exploitation of films.
So you say that's that?
That's that.
Thank you.
I mean, the converse would have been, had they succeeded in the enterprise of creating a trade, they would have had a huge loss in the first year. I mean, this is not a legal argument at all. It's not even a merits-based argument, it's just an observation. They would have succeeded in getting a large loss to be set off against and to shelter whatever profits that were sought to be sheltered elsewhere by way of sideways loss relief. And then they would not have had, and then they might still have had a question about the maps, because the maps would have been income arising in that year, assuming that they couldn't set off the deductions.
Thank you very much. Yes, it's probably a reply.
Early on in my learned friend's submissions yesterday, she helpfully clarified that the revenue agree that the income that's being charged to tax here are the minimum annual payments themselves. The statutory question is whether the appellant was the person entitled to those payments. And we know from the decision in Khan that the person entitled to the payment means the person with the right to the payment. And in order to have a right to the payment, the person must have an enforceable right to the payment. And so we say that all the factors relied on by the revenue of constituting an entitlement, the nebulous concept of continued dominion over the maps, the potential for benefit under the general matrix of the contractual arrangements, are nothing to the point.
So are you saying that Mr. Good could not have sued SD for an order that it pay to bank the map? Because that's the acid test, isn't it?
The acid test is who has the right to the payment. And the person, the right to the payment, whether the assignment was in equity or in law, was Scion Bank.
Well, no, why isn't it the case, answering your question, that Mr. Good had an enforceable right, as against SDL, to require it to make payment of the map, but to the bank? I mean, he remained entitled to enforce that right. In fact, the bank, it's the point I raised this morning, the bank itself, I think, could not, certainly according with modern law, couldn't have sued the SDL without, save in exceptional circumstances which don't apply in this case, joining Mr. Good
as a procedural matter, that is quite correct. The difference between the legal assignment and the equitable assignment is that under legal assignment, that the assignee can bring the action in his own name. In the equitable assignment,
and there's lots of debate about what the nature of the requirement to join the assignor is.
Yeah.
But actually, the real question that you just posed, I thought, gave rise to the question: could Mr. Good sue SDL for payment of the maps, requiring SDL to pay to the bank, such that he would then have his loan from the bank discharged pro tanto?
But the starting point is that Scion Distribution, cannot make a payment to the bank because it's been given notice. That was the case of Jones that was cited in the deposit bank case.
No, I mean, SDL has been told by a notice, pay bank. Suppose SDL just says, can't be bothered, don't want to. Why is Mr. Good not able to bring proceedings against SDL to say, you owe the map, I am the person who contractually you owe it to, you, SDL, have not contractually agreed to pay it to the bank, that's the point I made about the notice. So I am now seeking to enforce the contractual right to payment of the map, albeit that because I've given notice and I have also obligations to the bank, I will seek an order that you make payment direct to the bank.
But who gets the payment at the end of...
The bank does.
The bank.
But you posed the question, does the person, I wrote it down, I think, does the person have an enforceable right to the payment?
To get the payment,
Well,
yes.
actually, I can't at the moment see why Mr. Good doesn't have an enforceable right to the payment, albeit that he wishes it to be directed to somebody else. But he is the one that has the enforceable right.
Because if he is the, as the extract from Snell we saw earlier, if he is the assignee, if it's the assignor in equity, suppose, he holds the legal title on trust for the assignee. So
he holds the right of action under the contract. That's what the legal title is.
So the result of the action will be the payment is made to the assignee.
Correct.
So the person with the right to the payment is the assignee.
No, the question of who is entitled to enforce the right is the person. I mean, it's okay. It depends how your question was phrased in terms of does the person have an enforceable right to the payment? And I suggest he does, albeit that he would like the payment to be made to somebody who is a creditor of his.
But he's only acting in his capacity as trustee for the bank, the assignee. So the assignee has the equitable right. The assignee has the equitable right to the payment, which it can enforce and get the payment. What's the alternative? They can.
Well, they both can. I mean, this is the point that the cases do show, I think, quite clearly that the assignor can bring the claim. Very often it's not the assignor who wants to. And the real question in a lot of cases is, can the assignee, who has the, as it were, the economic interest in pursuing the debt? And it said, yes, he can. But he usually, as a matter of process, has to join, or it's arguably whether it's process or substance. But in any event, it's certainly the case that procedurally he has to join the assignor. But there are a number of cases, and I don't know what they are at the moment, but I'm probably having to look them up. I saw them yesterday, which says that the assignor retains the right to bring proceedings to enforce the debt. And obviously, if he were to recover to himself, he would hold it on proceeds on trust for the assignee. But he can equally just ask for an order that the debtor pays direct to the assignee, which he may well want to, as in this case, because it discharges his obligations to the assignee. So it depends where you put the emphasis in the sentence that you posed as the question. You say the payment, which comes back to this question of what does receiving or entitled mean. Mm-hmm. But if you're actually asking who's got an enforceable right, I put it again. I mean, are you saying that Mr. Good does not have an enforceable right?
He does not have an enforceable right to obtain the payment, and that must be the test for.
Why couldn't he enforce? Why couldn't he say, actually, he could obtain the payment for himself, albeit he would then hold the money on trust for the assignee? Suppose the bank said in this case, look, you sort yourself out with your debtor. We don't want to get involved. You know, we're happy to trust you, but if you get the money, you'll hold it, obviously, on trust for us.
Then he's just, what he's doing then is satisfying the assignee's equitable right to the payment.
Correct.
And that is the person that gets the payment is the bank, in satisfaction of his right to get the payment.
See, a very simple person might say the bank is the person receiving under the first limb of section 611, and the person entitled is Mr. Good. It
cannot be denied that the bank has the right in equity to the payment. The right in equity trumps everything else in this case, because if you're looking to see who is the party with the right to the payment for income tax purposes, the person with the right to the payment is the person with the right actually to be paid, and that is only Sion Bank. It's not Mr. Good. In no circumstances can obtain this payment in such a way that should probably be recognised as something that is taxable in his own right.
So who can enforce it? To go back to your original question, actually, you say, sorry, it doesn't really matter. Actually, it's the emphasis should be on the word to the payment in that question you posed.
Yes, it's the income. We know that the statutory language is entitlement, entitled to the income. The income in this case is the payment. The question in this case, who has the right to that payment? Who can get the payment? And Mr. Good, subject to the arguments I take you to about what the assignment actually achieves.
So why didn't the statute 611 just have the word receive? I mean, why bother putting the word entitlement or entitled? I mean, why not just have the person receiving?
Well, because in a case where a person does have the equitable right to income, or the legal right to income at the time it falls due, and that person says, for example, pay the income to my child or some other entity that pays less tax, the revenue would want to choose in that case.
Well, isn't that exactly what's happening here? Albeit by way of a document in advance, but operating in relation to each of the debts as they fall due.
But
Mr. Good has said, I'd really prefer you to pay these amounts to the bank to discharge my debt.
But he's done much more than that, because he was required to give up his whole interest in the maps and assign.
But he
that
hasn't
right.
given up his whole interest, because he retains, it's only by way of charge or security, he retains the equity of redemption at the very least.
Okay, he isn't. He may become entitled to maps once the equity of redemption comes in, but for the time being of the security, at that point he has irrevocably assigned those rights to Scion Bank. So can Mr. Good do anything to obtain the income for himself, which must be what the Income Tax Act is getting at? Has he got the entitlement to that income, an actual right to get the income? If you've got the right to get the income, and you say it should be paid to somebody else so that somebody else receives it, one can see why the Act would want to ensure that the revenue can follow the money and assess the person who's actually received the income. But you've still got to ask the question, does the person in the first place have a right? And that turns on the effect of the assignment. So does it make a difference whether it's equitable or legal? Why should it? If the effect of the assignment is to transfer the right to a payment to the assignee, then that is the person that has got the right to the payment.
But distribution's legal obligation is to pay the money to Mr. Good. The notice.
Yes, although the one important reservation to that is that, as pointed out in the Deposit Protection Board case, is that once notice of an equitable assignment is given to the debtor, he cannot thereafter deal inconsistently with the assigned interest, for instance, by making payment to the assignor, Jones and Farrell. So,
Sorry, can you just take us to that?
that was in the deposit case, tab 28. Page 12 of the report. The deposit case sort of followed. This was the last case in that little clip. Paragraph 4 at the top. So it wasn't simply in this case that Scion Distribution was given notice. It was a party to the agreement under which notice was given, and the effect of that is that it wasn't able to make the payment to Mr. Good. The only person that would get the payment was Scion Bank, and that was in satisfaction of its equitable right to that payment.
When it says he cannot deal, what wrong does he? I must admit I haven't looked at those two cases, but I mean, when it says he cannot, I mean, I really understood this as being its protection for the assignee. In a sense, it's extra protection for the assignee's equitable interest, because one assumes that the notice will be complied with by the debtor. But when it says he cannot, do you mean he cannot legally? I mean, he doesn't commit a legal wrong if he pays the debtor, pays the assignor, does he? I mean, I wonder. I just wonder whether those cases go quite as far as that statement. I mean, is it a legal wrong for the debtor to pay the assignor if it's only an equitable assignment? He doesn't commit a legal wrong, does he? Because after all, he's paying the legal owner of the debt. He will get a good discharge by paying the assignor. It's just that everybody would prefer that he didn't. But it's not legal wrong.
Maybe it may not be a legal wrong.
I just wonder whether that use of the word cannot is a little bit strong for what those cases actually decide, because that's not my understanding.
No, but it would be inconsistent with the equitable rights conferred on the bank.
And that's why you normally, even with an equitable assignment, you normally would want notice to be given to protect the equity. But it's not as a matter of law. I think it's as a matter of commercial practice. Anyway, maybe those cases say something different, but I'd have to I'd have to have a look at those. Anyway, okay. Because my clear understanding, as you pointed out, is that the person legally entitled remains the assignor. You know, he's contractually still bound by privity of contract with the debtor.
But so, not in a way that enables him to obtain the payment.
That's your payment point, if I may say, rather than the which is a different point, I think, from saying that the debtor is prohibited or in some way can't pay the assignor.
One's looking at section 611, and it's looking at the person entitled to the payment, and asks, well, was Mr. Good entitled to the payment, or was Sion Bank entitled to the payment? Then there can only be one answer, that Sion Bank.
You see, I think they're each entitled to enforce the obligation that SDL has. Your point is that's actually, now we've teased it out, not the test. The test is to whom will the payment be made. That's your point.
Who has the right that will ensure that the payment is made to them? Who can secure the payment to themselves? Who has the enforceable right to ensure the payment comes to them?
The ultimate enforceable right, if you will. Yeah. Then it goes back to why the statute includes two alternatives. One is receipt and one is.
But
you say they're one and the same.
In the present case, certainly, but in another case, if the person with the right to the payment and hasn't assigned it just got the right to the payment, simply says, as the payment is arising or the day before, please actually send the money to somebody else.
Yeah, but that's actually an equitable assignment. The cases do show that if you do that, that's if you direct a fund coming due to you to be paid to somebody else, that is in fact an equitable assignment. You don't need any formality for that.
But but in that case, the income, you're asking, well, who has the right to the income? All that's happened is that the pure income has sort of flowed over, but the person with the actual right in this case is by looking at the deed of assignment. And so I should just take you to that, because I wanted to just to deal with the argument that there wasn't an assignment in the present case, and what clause 3.1 means.
Where are you taking us?
That assignment deed at tab 38. Just to say it is what we say has been assigned. I think it's quite clear. 3.1 on page 551. Mr. Good unconditionally, irrevocably assigns for the payment of the secured obligations all of your present and future right and title and interest in the film rights and the benefit of your present and future rights under the acquisition agreement, including the distribution rights acquired thereunder. pause. Mr. Good did acquire film rights under the acquisition agreement. That was the only agreement under which he acquired film rights. So, including, you put a comma after acquisition agreement, comma, including the distribution rights acquired thereunder, comma, because those are the only, that's the only agreement to which those relate. And he's assigning the benefit of his future and present rights under the distribution agreement, including, without limitation, the benefit of all income or money payable to you in respect thereof, including the benefit of all proceeds payable to you in respect of your distribution rights therein, and all royalties, fees and other payments and income paid or payable in relation thereto by way of repayment of the purchase rights. So he is assigning both things. He's assigning all his rights in the film rights and all other rights he's got under the acquisition agreement, and he's assigning all his rights, including the income, the benefit of the income, under clause 3.1. So it is absolutely clear that what is being assigned here is his entire interest in the distribution agreement, including the benefit of the income, and that includes the maps. So he has made a complete assignment, subject to reassignment, at the end of the period, of his rights to the maps and his entitlement to income arising from the maps. That is what clause 3.1 is doing, and it remains. I say it doesn't make any difference on my case, but it does remain open to argument whether that is a equitable assignment or a statutory assignment. There's the extract from Chitty I handed up suggests that this is a statutory assignment, because it's not as an assignment of part of a debt. It's not an assignment by way of charge. It's an assignment by way of security, but it is a complete assignment of these rights. The clue is in the title and the differentiation between clause 3.1 and 3.2. He unconditionally and irrevocably assigns all his benefits under the distribution agreement, except for the reserved collateral, 55%. So by that, he unconditionally and irrevocably assigns all his interest in the maps. And then at 3.2, he separately, unconditionally and irrevocably charges, to the extent not assigned under clause 3.1, everything subject matter of 3.1. So there seems to be some residual belt and braces charge just in case, but under clause 3.1 on the face of it, it's a charge, it's an assignment by way of security, but it's an assignment of everything. The fact that there is an agreement to release and reassign the maps back to Mr. Good after the secured obligations have been paid, doesn't, as on any mortgage, doesn't stop the security being and a security by way of an absolute assignment. The passage from Chitty that I handed up would appear to support that analysis. One's got to look carefully at whether the whole bundle of rights that's being assigned actually puts the entire relationship in relation to the maps creates a relationship, an exclusive relationship as between Scion Bank and the debtor. So the extract from Chitty, you have it there, it's at the end of the bundle. In passing, I rely on paragraphs 19004 to 19005 as representing a relevant analysis for you to take into account when looking at who has the right here, because essentially what is being said that in substance an equitable assignment and a legal assignment are the same.
That might have, I think we've been around this
yes,
circuit
exactly.
before. That might well have caused you real problems on establishing a trade. And it sounds like a bit of wishful thinking, I
yes.
may respectfully suggest.
Yeah. But turning to section 136, we see the wording 136 itself on 19007. It says that an absolute assignment by writing under the hand of the assignor, not purporting to be by way of charge only, of which notice is given to the debtor, takes effect in law. So I would say that clause 3.1 appears to be an absolute assignment by writing under the hand of the assignor, and it is not purporting to be by way of charge only. That is distinction is brought out in 1913 on page 1514. The editors summarise the cases. And they make the point that an ordinary assignment by way of mortgage may be absolute within the meaning of the section if there is an express or implied proviso for reassignment on repayment of the loan.
I mean, 13 is just dealing with effectively the ways in which you might you have to interpret whatever the document is.
Yes.
I mean, here we have a document which says in innumerable places that it's intended to be a charge.
It depends whether you.
I appreciate labels are not absolutely conclusive, but
is the assignment. It is notable that 3.1 is expressed to be an assignment, and 3.2 expresses the charge to be on what is not assigned. The editors conclude the test being.
hang on. Sorry, 3.1 says you unconditionally and irrevocably assign blah 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 by way of security, and then it gives various things.
Yes, and I think that the distinction is between security or by way of charge. What is expressly excluded is something by way of charge, and at 1903 in the middle, the Chitty editors say an assignment of monies due to become from the debtor, which was expressed to be by way of continuing security for monies due from the assignor to the assignee, has been held to be absolute. So there isn't a complete block on the fact it being a security, that it also is a security by way of charge. And then they say, on the other hand, where an assignor charged the sum, which would become due to him from the debtor as security for his for advances made to him by the assignee, and assigned his interest in that sum until the advances were paid to the assignee, this was held to be by way of charge.
I mean, that looks rather more like clause 3.1, doesn't it?
Well, no, because the charge is expressly limited to the things that are not assigned. And the conclusion that Chitty reaches, that the test seems to be, has the assignor, this is at the top of page 1515, has the assignor unconditionally transferred to the assignee for the time being the sole right to the debt in question as against the debtor. If so, the assignment will be absolute, but if the debtor cannot tell whether to pay the assignor or the assignee without examining the state of accounts between them, it will be held to be by way of charge only. Much may depend on the language of the particular instrument. So certainly in the present case, the sole right to the maps, sole debt as against Scion distribution, is unconditionally transferred to Scion Bank.
So actually, are you saying that 3.1 affects a legal assignment, and to the extent it fails, 3.2 affects?
That is how it appears to be drafted.
So just so that I'm clear, so your case is that this is not an equitable assignment. This is a legal assignment.
Yes, my primary case is that it doesn't matter. My primary case is that whether you're looking at the equitable right or whether you're looking
because
at
of your payment argument,
the legal right, the person with the right to the payment is Scion Bank, and how could it matter whether it's a legal assignment or an equitable assignment? But on the particular wording of clause 3.1, it appears to be an absolute assignment because it is unconditionally assigning everything. It's not the rights of the entire interest that Mr. Good had to the maps, the benefit of the income, everything.
But it's not. How can? So I mean, the difficulty is with the argument that it's absolute. The closing words of 3.1, apart from the fact it's said to be security.
It is absolute for its duration. And I think that it seems to be accepted that if you can have a provision for reassignment, as we have here, at the end of the security, under clause 7, then as with any mortgage security where the right of the redemption exists and comes in there is a reassignment of everything at the end of the security. It doesn't prevent it being an absolute.
So you say 3.1 affects a legal assignment, an absolute legal assignment, and only if for some reason it failed does 3.2 come in with a charge. So, I know you say it doesn't matter.
Yeah.
But if we were to go down this analysis, you say in fact 3.1 coupled with 7 is a legal assignment once notice is given, which you say it was. Therefore, it is a legal assignment, which is effective to make Mr. Good the holder of nothing.
To eradicate any former entitlement.
Yes.
Yes, I think we have your argument on that.
Okay.
Yeah, okay, well, yeah.
But you also have my primary argument is that there should not be a difference when one's looking at the concept of a right to payment, whether that is an equitable right or not.
Anything else that we wish to deal with by way of
Well, just to say, if that is the right way of looking at it,
Sorry, which right way? Payment
if
or
it is
absolute?
correct,
Yes.
to ask the question, who has the right to secure the payment, then all the more nebulous concepts of dominion over the rights, lingering entitlement by virtue of the contractual matrix, potential benefit arising out of the transaction, they all fall away. None of those things improve Mr. Good's entitlement right to the payment.
So it's your submission that that is the right way to ask the question, who has the right to secure payment? And forgive me if I've just dropped a stitch here, but is there any authority, is there anything to help us to say that is the right way when you're construing section 611?
I'm relying on Khan, because Khan says entitled means right. Entitled means you ask the question, who has the right to the income? And the right must be the enforceable right. So that is how we invite you to interpret section 611. The right answer to this case is that a person who neither received nor has any enforceable right to secure the income, it is not liable to tax under section 611. And that is not a surprising result to arrive at. Those are my submissions.
Anything else?
Just only very quickly, just to give you a chance to deal with it. You took us to paragraph 4 of the decision in Deposit Protection Board and Barclays Bank, and I questioned whether the authority stood as proposition for that proposition. While you've been talking, I've been had one eye on another textbook, and I think what Bryce and Bannister indicates is that if notice of an equitable assignment is given to the debtor, and the debtor nonetheless pays the assignor, the problem for the debtor is he doesn't get a good discharge.
Yes, in practical terms, that is why.
It's not unlawful,
No.
but it just won't achieve the result. And then there's a massive debate in the authorities about whether in those circumstances the recipient holds the money on trust for the assignor, holds the money on trust for the assignee, and what remedy, if any, the debtor would have in restitution to get the money back. Do you want to say anything more about that, or is that just a rabbit hole down which we don't need to disappear?
That just is completely consistent with the reason why the equitable assignee joins as a matter of practice, joins the assignor, because that will ensure that the discharge is effected. but it doesn't affect the burden of my argument that the relevant right we're looking at here is the equitable right to the payment, if it was an equitable assignment.
Is there anything you wanted to say about Chitty?
Thank you for the opportunity. All I was going to say is that, as my Lord Justice Snowden said, what these paragraphs show is that it's necessary to read the document in its entirety to understand what it is that it's intended. So picking and choosing particular passages from it and from Chitty are not going to take one much further, because cases are decided on their own facts, and the summary may overstate the position. So to the extent that it is thought that the footnoted passage, an assignment in 19013, an assignment of all monies due or become due from the debtor, which is expressed to be by way of continuing security on all monies due from the assignment of the assignor, has been held to be absolute. Well, that's footnoted at 44 as the Hughes and Pump House case. That's one analysis on one case. But all the cases say you have to look at the document in its entirety. We say that the document here creates not an absolute assignment under clause 3.1, and you have our submissions on that.
Thank you. That's most helpful. Well, thank you both very much indeed. Thank you, Ms. Nathan, with your cast behind you, who obviously all worked extremely hard on your behalf, but also, I have to say, Mr. Baldry, to your instructing sister behind you, you've clearly had a much smaller team, which no doubt has involved an enormous amount of work, for which we're grateful, and notwithstanding that, the bundles and so on have been prepared beautifully and have been extremely well easy to manipulate and manage. So thank you for that, because that makes preparation in a complex case like this infinitely easier. So we'll go on in the normal way from then. We obviously will reserve our judgments. I can't make you any promises at all when they will be handed down, but we hope that not too long. They'll be sent out in the normal way in draft. May I emphasise that they will be embargoed. From the point of view of your team, Ms. Nathan, there has to be a very clear understanding about who will see our draft judgments, and if necessary will request names of who they're to be distributed. That's not in any way to impugn your team, but where you come from a very large organisation, as you do, there's always the danger that suddenly we find 50 people, it's been essential 50 people have seen our judgments in draft, and obviously that is not appropriate. Then submissions in normal way, typographical errors, grammaticals, infelicities, not an opportunity to re-argue, please. And in due course it will be handed down electronically, and we'd ask that any further submissions, for example by COS, if you can't be agreed, to be done on paper. Thank you all very much.
Course raised.